I am a UK-US citizen, recently moved from the US to the UK. Should I have a UK will to cover my UK assets and a US will to cover my US assets? Great question, comes up all the time. Roger?
So in general, for a lot of, let's assume you've got no real property, no real estate in the United States. Then a US will, a UK will rather, would probably be sufficient for all of your worldwide assets. The only little tweak I'd put on there is you probably want an English will, to be more specific. English wills are just more flexible, easier to administer. But you certainly want to make sure that your solicitor who's preparing your UK will understands that the intent is to cover your worldwide assets, including whatever assets you have in the United States. But that shouldn't be a problem. It can be problematic if you have two wills and it's not clear that they were designed and written to work together, in which case you may find one of them has canceled the other. Wills often start with statements like, this hereby revokes all prior wills. That could be a real problem.
Yeah, I would agree. Generally, we advise against ever using multiple wills because of various problems, including, most importantly, the one that Roger just described, which the wills, if they are inconsistent or potentially canceling each other out, just creates all kinds of problems. I would expand here. Even if you have U.S. assets such as real estate in the U.S., if your UK will is properly designed to cover your worldwide assets, as Roger describes, that will would be perfectly valid in a U.S. court to direct the probate of U.S. real estate, right? Because U.S. courts will acknowledge that the owner of that real estate was a domicile, in this case of the UK, and they will refer then to the UK probate process and the UK laws of succession that apply. And this is done quite routinely in US courts, right? Because most countries do acknowledge the right of other countries to impose their succession on their domiciles.